Welcome to Board Game Publisher. Today, I will continue discussing the licensing of games from a designer, so do not miss the other videos on the same series. The topic for today will be the duration of rights and the reversion of rights that you license from the designer. When you make a contract with a game designer about a game, there are a series of time limits that you have to put into the contract and that you have to agree upon, of course, with the designer of the game. The first thing that you have to agree on will be how long can elapse between the moment that you agree that you will publish the game and the moment that you actually publish the game, the moment that the game comes out of the factory and is ready to reach distribution and then the retailer shelves. It can be a long time. For some of the games that I've been working on, it has been more than 3 or 4 years between the first agreement with the game designer and the published game. So you have to make sure that you account for that when you make your contract. Because if you say, yeah, the game will be published next year, and if it's not published next year, okay, the contract is null and void. Things can happen. You may need more time than that, and if you need more time than that, then you will need to renegotiate the contract with the designer. This is not a good position to find yourself in. Another important aspect, of course, is not to put too long a time, because if you tell the designer, okay, I want your game, I sign it, I will publish it in the next 10 years, the designer will not agree with that, because in 10 years, your company may not be there anymore. There are no guarantees that you will actually publish the game. So the designer will want to make sure that when you commit to publishing the game, you will actually publish it. You have to find a good duration for that. The ballpark figure, in my experience, is usually 2 to 3 years between the first agreement that, yes, I'm going to publish the game, and the game being actually available for the gamers, or distribution and for the gamers. So that's a ballpark figure, but of course your mileage may vary, and you will have to adapt that according to your game, according to your flow, according to your resources, according to the needs of the designer. Each game is very different. This is a bespoke process, so it's very hard to give a hard and fast duration and tell, yeah, you must use that kind of that duration. It doesn't work that way. I wish it would, but it doesn't work that way. Another aspect that you have to take care about is the duration of the license. So once the game is published, how long can the publisher keep publishing it? Usually this is a limited duration that is agreed upon by the designer and by the publisher. I like to have 5 years of publication worth when I sign a license for a game, so that I will have the time as a publisher to establish the game, to market it, and to sell all the copies that I have made. Also, I usually have an automatic renewal clause in the contract that says, okay, if the game is doing well, if I keep reprinting, the contract will renew automatically for a new period. It's usually 1 year after the 5-year period, and each year it keeps renewing unless the game is not in publication anymore, so it's not sold at all. In that case, the contract elapses. Unless the game designer wants to claim the rights back, it's a possibility that they have in the contract as well. If they are not happy with the sales, if they are not happy with the volumes, they can say, okay, I will get the game back, please sell out what remains of your stock, and then it's my game again, and I will peddle it to another game publisher. This does not happen very often, but it can happen. What happens most of the time is the game comes out of print. It does not make sense for me to reprint it, to recommit money, because I'm not sure that I will be able to recoup that investment in a reasonable amount of time. So if I can print 3,000 copies and I know I will need 10 years to sell that back, it does not make sense to invest the money to print again. So in that case, I will let the contract lapse and the rights will revert to the game designer. Right reversion is something very important that you have to take care about into your contracts with the game designer. This protects mostly the game designer, but it's a very important thing anyway. It's not only the publisher side that you have to take into account with this. There are several cases in which the rights should revert automatically to the game designer. The first one is if your company fails. So if you go bankrupt, if you cease to exist as a board game publisher, it only makes sense that the rights should revert to the author of the game. That's one thing. Another thing, and that is not something that everybody will agree with. In my opinion, it should be that way. If you sell the company, you should give the authors the opportunity to carry on or to get the rights back, depending on whether they agree or not with the company that you are selling to or the people that you are selling the company to. This is a major change in the company. It's not the same publisher anymore. The designer is someone very, very important into the designs. And so you have to take that into account and allow them to have their say in that process. I said it will be contentious and not everyone will agree with this because some publishers see the amount of games they have as the assets of the company. And of course, it participates into raising the value of the company. And if you give away, if you let the designer get the rights back when you set up the company, then it's not part of the company anymore. So it's only the company that you are selling. It's not the catalog of games that you have. Most of the time, you will be able to find an amicable agreement between the buyer of the company and the game designers. But still, it's a good thing to have that kind of event planned into your contract from the get-go so that if it happens, you don't find yourself in a delicate situation. That's exactly what contracts are for. You plan all of the bad things and all the weird things that could happen along the way. And when they happen, you just follow the plan and everyone knows exactly what to expect. So that's the best way to do that. Another very important aspect also that you have to take care into the contract when you license a game from a designer is the sub-licensing aspect. So what is sub-licensing? Sub-licensing is when I, as a publisher, will allow another publisher to publish the game that I have the license to. This usually happens for other countries and other languages. Flatline Game is a very good example of that. I am a very small company, that's just me with a side job, so it's not my day job being a board game publisher. I have another job and I do this on the side. And I have limited resources in terms of marketing, in terms of production, in terms of work capacity. What I do is when I publish a game, usually I publish it in 4 languages. I do French, English, Dutch and German because I have the opportunity to have the translation in these languages easily. It's part of my process. I usually go to the Essenspiel game fair every year so that if I have a new release, the German language into the release will help me, of course. And beyond that, all other languages I try to find partners for. So I have the games in French, Dutch, English and German. I sell them through distribution in Belgium and in France mostly. I have a few deals depending on the game. It's for each game it's a different negotiation with a few external partners. And when I get a partner, they usually get a license for a given language and or a given geographic area. For instance, if it's an American partner, like I did with Stronghold Games to publish Steamrollers, they have the rights for all of the Northern America. It's not an English language right that I sub-license to them. It's all of Northern America because they cover all of that territory and I am not present there. I have no marketing resources. I cannot do events there myself because it's way too far from Belgium. So I find a partner for that and they have a license to publish the game in their language on their territory. It was the same in Poland for Steamroller with Portal Games. Portal Games has the rights for the Polish language for the game and they can publish it. And they are not limited to Poland. They can sell it wherever they want, but only in the Polish language. So depending on the situation, you will want to license based on the language or based on a geographical territory. It's really depending on the partners you are licensing, on the game that you are licensing. It's a game per game negotiation, I would say. If I do sub-license a game, it's something that is already foreseen in the contract that I have with the game designer. So when I do a contract with a game designer, they know that I will publish the game myself in some languages and that I will myself go to partner and find deals with other partners to publish the game in other languages worldwide. Of course, the royalties they will get are not the same, but I will discuss royalties in another video. Sub-licensing is a very important aspect of the board game licensing and it's something that you have to take care about into your contract. So as usual, if you find this video interesting, give it a thumbs up. If you did not find it interesting, give it a thumbs down and by all means leave a comment so I know exactly what to improve on that. Also, if you want to make sure to see all of the videos, subscribe and hit the notification bell. Thank you.